rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. This is a time set for oral argument in case number IC22 0047, Gomez versus QUIKTRIP. Council, just to remind you, we're recording and live streaming the argument, so please identify yourselves and who you represent at the beginning of your argument. Each of you will have 20 minutes to present your arguments, although you need not use all your time if not merited. Appellant's counsel, if you remember to, you're responsible to watch the clock and reserve as much time as you desire for rebuttal. Also, if you keep in mind, we've read the briefs, we've studied the record, and we've discussed the case in conference. Counsel for appellant, you may proceed.
Thank you. Good morning, and it may please the court. My name is Tom Wilmer. I'm here on behalf of the petitioner, Matthew Gomez. And as a prefatory note, I want to make sure the court does have the video, the actual video itself.
It's my understanding, can you hear me okay?
Yeah.
Yeah, that we do not have the video. We have what's provided in your brief with the still shots.
It's pretty important that you have that. So I guess the question is, can we supplement the record to make sure that the court has the video? It should have been part of the record that the commission should have provided to the court.
Do you know what format that was in? When it was
some type of video file. That's how it was uploaded to the commission record.
Was it admitted during the hearing?
Yeah, it was. It wasn't. It was reviewed by the ALJ. So it's the most crucial piece of evidence for the court to review here. I mean, it is the most crucial piece of evidence.
Well, let's go through argument, and then before you sit down, let's revisit that. I'd like to know more why it's crucial to the case. So
okay, this is a very narrow issue that's before the court. In the case below, it's undisputed that my client had a fall due to a personal reason. He fainted. We don't know why. What we do know is that he fainted. The doctors say he had a syncopal event. What we do know is that as a result of that fall, he struck his head. The doctors agree that as a result of that fall, he developed some type of a post-traumatic seizure disorder. What our argument is that the workplace contributed to that fall. And I want to read to you a quote from one of the cases that is attached to the respondent's answering brief as one of the exhibits, because I think this sums up the question perfectly. And it's a quote from the Benco manufacturing case, and it's citing a Hansen case. It's an out-of-state authority, but it's perfect. It says claimant must prove that a causal connection exists between the conditions of his employment and his injury. In other words, the injury must not have coincidentally occurred while at work, but must in some way be caused or be related to the working environment or the conditions of his employment. And in this case, as the video shows, he falls forward into the drink rack, into the cups. And as a result of that, he slides to his left, and it causes him to twist and turn backwards. So, but for him being in this unique employment environment, he would not have fallen backwards and struck his head.
So go ahead.
So would your rule be that anytime you contact something in your physical work environment, there's work causation? Because that's sort of what it sounds like, your presentation of that. That's what it means.
If there's something unique about that is going to aggravate the extent of the direction of the fall, for example, then yes. And one of the cases also cited in my brief is the Irby case, which is also out of state authority. I think it's Alabama court says, and this is where somebody falls off of a stool, 2 to 3 feet off of the ground. The severity of the fall, angle, and position at which the appellant struck the ground were directly influenced by the 3 feet of the fall, one of the conditions of his employment. So
there, the condition of employment was using the stool.
right.
Okay, how is this different from falling into any counter any place? Because anything you bump, a table, the cash register area, one of the shelves, the soda, where the sodas are, you fall into the glass, anything like that would have changed the direction. But how is that related to the employment? What makes, because you used the word unique, what makes this counter so unique that we should consider that?
You don't have drink cups.
How did the drink, any evidence the drink cups affected this?
Well, if you guys had the video, you'd be able to see that. That's part of the problem we have here is you don't have a complete record on review here, which I think is going to help you tremendously.
But was there testimony provided about the implications flowing from falling into the
video
drink cups?
The video speaks for itself.
Well,
No, I just wondered, there was no testimony provided on that?
No, none whatsoever.
so wouldn't we be speculating at this point to say that the drink cups had an impact? Was there argument made it was the drink cups?
In my post-hearing memorandum, that's what I argued to the ALJ. He's fallen forward. He is clearly falling forward. If that was not there, he would have fallen forward onto his face.
Do we know that?
It's pretty evident.
He was also kind of collapsing. I mean, he could have landed on his knees and fallen backwards.
He could
It's
have.
speculation.
But wait, was there expert testimony that falling on your face would not have triggered the problem? Had it not been the same outcome?
It's not his burden to prove what's not knowable. What my client's burden to prove is what happened. He proved that he fell, he struck his head. As a result of that, he sustained an injury. He doesn't have to prove what the what ifs are.
But it's an idiopathic injury.
It's idiopathic. I agree with that.
Okay,
Right.
so that does.
So that
Unfortunately for your client, it was on video. I mean, it was captured on video, so that we know that that's what it was. But that takes you into the squarely outside of the Circle K type situation with under the positional risk doctrine, right? It takes
Circle K is an unexplained fall case.
right.
So
So
there's
this
a-
is not unexplained.
Yeah, Circle K is an unexplained fall, so there's a presumption that it's work related. This is idiopathic.
Right. So there's no presumption. So how did you?
I have to prove that there's some contribution. There's some contribution. And like I said,
Well, that goes back to my first question. So anytime you touch anything at work, then work contributed. That's your theory, right?
it depends. If
What would be an example of a non-contributing surface at work? How would that play out?
well,
Like, because if you're not every case where you contact something at work,
Well,
a rule for us to apply, would be helpful. It would be helpful to know the distinction between things we contact that create injury and things we contact that don't. Is it that the object could have been in any other workplace? Is that the idea or not?
no, if you're at work and you pass out and you fall onto the couch, yeah, that would not be compensable. But in this case, it's clearly steering this guy backwards to where he falls on his head. Here's an example. Let's say that you're at work and you hit the counter, but you're right on the edge of a stairwell where there's no guardrail. And as a result of that, down you go. Under that scenario, that would be compensable. At least that would be a pretty good argument to say it's compensable. And the cases that address this situation where it's an idiopathic fall, they basically fall into two different hoppers. One is there's something about the work that exposes the worker to an increased injury. In other words, they're standing next to the buzzsaw, or they're working around dangerous machinery. The other is they're on at some height. And a result of that, the fall, it worsens the injury. There's some contribution to a worsening of the injury. And that's what you have here. It's actually steering the guy backwards.
Was there testimony that said that if he had fallen forward, whether it would have caused this injury, that he would not have sustained as severe an injury? Any evidence?
Well, none of
Okay.
that. But
So we don't know that it really had changed the severity of the injury.
that gets to what I pointed out in my reply brief. There's what's knowable and there's what's unknowable.
But who bears the burden of proof? It's your client.
And my client met his burden of proof because
By saying he fell
proved
in the
what's-
workplace.
He proved what's knowable.
Well, let's revisit proved. What is the standard of review for the ALJ's factual findings?
Well, I think we have kind of a mixed question of law and fact here.
Well, no, let's talk about what is the standard of review for factual findings?
Substantial evidence.
We defer substantially
Mhm.
and it's an abuse of discretion, right?
Unless it's clearly erroneous.
Clearly erroneous, all right,
Right.
clearly erroneous. How is it clearly erroneous that the court said the presence of the drink machine and cabinetry may actually have lessened the severity of the ultimate impact?
There's
That's
no-
a fact finding,
Well,
and it's got to be clearly erroneous.
as I submitted, well, you guys don't have the video. That's
We have the
problem.
pictures in your brief. We have about 30 still frames and they're
Right.
pretty helpful for me.
All right.
But circling back to the video, was that shown at the hearing?
Yes.
To the
Well,
ALJ.
it wasn't shown at the hearing, but the judge had it.
But do you know if the judge reviewed it? The
Presumably
ALJ?
she did. She makes reference to it. I did not submit stills. The only stills in the record are what's in my brief. So she had the video and she had to review it and Dr. Khan reviewed it. So, because he testified to it. So,
I have to come back to my question. I asked you how it was an abuse of discretion. Your answer was you don't have the video. Let's assume we get the video.
Mhm.
Tell me, when I look at the video, what are we supposed to see that will constitute the abuse of discretion? That's the answer I need to hear.
the video speaks for itself.
No, you need to tell me, when I look in the video, what I see
Mhm.
that the judge was clearly wrong about. You can't say the video speaks for itself.
How about an example? You have a video of a traffic.
Now, let's use the video here as the example. I have a video of someone falling into a cabinet, so use that as your example.
She says in her finding that there's no proof that he would have fallen forward. And the video it speaks to the contrary. And as I said, this really falls into a mixed question of law and fact. And I have to concede that that's a confusing question. And I did some digging on it to find out how to address that. And I came across some information that's on one of the federal court websites. And there's a good case called Thompson versus Keohane, Keohane, 116 Supreme Court 457. It talks about 3 different categories of fact. And there's basic facts, inferred facts, and ultimate findings of fact. And it says ultimate findings of fact, for example, whether an injury occurred in the course of employment, is an interest rate reasonable, has a company refused to bargain collectively. Those are ultimate findings of fact, and those are subject to de novo review. So,
Well, let's come back to the facts here. Your fact that you're talking about is, there's no evidence that he would have fallen forward. So my experience in cases is that when an accident happens and the issue is the physics of how it would have happened differently,
Mhm.
we have a lot of experts in that field. They're fall reconstructionists.
Mhm.
I suspect you're familiar with them.
Sure.
Was there any evidence from anybody that besides your argument, which seems to be common sense tells you he would have fallen forward, physics also often denies that common sense for us. Any evidence from an expert that says he would have fallen forward?
No.
So it's just, you want us to use a different common sense than the ALJ did in doing the analysis.
if you see the video, it's going to be clear to you.
Okay.
So was your client trying to brace himself on
No.
the shelf?
Now, if
How do you know that? He doesn't remember the incident. How would you know that?
If you look at the video, and I think Dr. Khan in his testimony says he's already basically passing out. As he's walking towards the drink cup dispenser area, he's already
So
already
he's not quite passed out enough to where he can't use his feet and stand, but he's so passed out that we know factually he's not trying to brace himself on an object.
correct.
And we know that because why?
I think Dr. Khan testified to that.
Okay.
He's already having his a syncopal event as he's walking towards the rack. And he's not trying to brace himself. He is falling forward. He is falling forward when it happens. So, like I said, it's pretty clear from the video, and I'm surprised that you don't have it. So I've got 6 minutes left here.
Counsel, let me follow up with that, and then I'll of course ask our opposing counsel, but what would it take to get the video? How soon could you provide the video?
Probably before the end of the week, maybe even end of the day.
And
I need to figure out what format.
Well, we need the video in the same form, exact same format from my point of view, we need the video in the exact same format in which it was presented to the ALJ.
Yeah, I'd have to go back and figure out how, because what we do is we submit it through a portal to the ICA. And so I'd have to go back to see if it was me that submitted it or if it was Mr. Lundmark that submitted it. I'm pretty sure it was me. But I need to figure out how to get that to you.
Well, let's hear Mr. Lundmark's position on this, and then we'll make a decision.
Thank you.
May it please the court, my name is David Lundmark and I represent the respondents QUIKTRIP. The issue in this case is, as you've correctly identified, a matter of fact-finding on the part of the ALJ. It's whether the ALJ reasonably determined that there was no evidence that the drink counter increased the applicant's risk of injury during his idiopathic fall. As the petitioners just noted, it's not disputed that the fall was idiopathic or due to a personal risk. Therefore, in order to establish compensability, the applicant has the burden to show that something about his employment increased his risk of injury. In the words of Valerio, above the risk of hazards to which mankind is normally exposed.
So I'm hoping you'll explain that to us throughout your argument.
In this case, I will try to do.
You can come back.
I'll try to do my best to explain that. Here, I wanted to bring up, though, that there was some evidence about what would have happened if he had fallen forward and hit the front of his head. And this actually is evidence provided by Dr. Crane, the petitioner's own expert, who, when he was asked about what he understood the history of the fall was, testified that the applicant was standing next to one of the machines and suddenly fell forward, hitting his head. And then he fell backwards on the ground, and there was a report of convulsions occurring at that time.
Based upon the still photos we have, that's absolutely false.
Correct. That is false. But what I'm saying is this is what Dr. Crane thought happened, and he still opined that due to this striking of his head, the applicant developed post-traumatic seizures after the fall. In fact, what happened is that he hit the back of his head and developed seizures. But there's testimony from the applicant's own expert that had he hit the front of his head, he would have developed the same symptoms. So I'm not sure that
Wait, clarify. If he would have hit his head on the soda fountain, it would have still developed the same seizures?
That's what it sounds like from his description. The upshot is that Crane says that he thought that he hit the front of his head and developed seizures, which is, I think, exactly what petitioner is trying to argue here, that but for the drink fountain, he would have hit the front of his head and not developed the same injury. But that seems not to be true based on this admittedly this testimony that has improper foundation, but still comes up with the conclusion that he could have hit the front of his head and developed the same symptoms. I hope I'm making that point clearly, that in fact he did hit the back of his head in an idiopathic fall and developed post-traumatic seizures. But there is testimony that had he fallen differently and hit the front of his head, the outcome would have been the same.
And what's the record reference for that?
This is on, I apologize, I don't have the correct site, but this is on page 7 of Dr. Crane's of the transcript of his testimony. line 16 through 24.
Right, so you're saying there's no contributing causation on the part of the workspace because in the absence of the rack, he could have had the same injury had he fallen forward into blank space, which is his argument.
That's
That's
right.
what you're saying.
That's the argument,
Thank you,
yes.
counsel.
And there's also the testimony of Dr. Khan that nothing in the workplace increased his risk of injury, that he's seen people have these syncopal events and fall forward or fall backwards or fall to the side and still experience traumatic brain injury as the applicant did here.
And is it your position then, as long as they don't, essentially, the damage or the injury doesn't occur like on the way down as part of the fall? Like, I'm going to just jump right to Larson on the sharp corner of a desk. As long as that's not present, just falling on the floor based upon Valerio is not enough.
That is correct, yes.
Why is that? So, I mean, just help me understand that. So I'll ask you personally, would you rather fall and hit your head on a floor that's carpeted like this right here? Or would you rather fall and hit your head in the QT store that is concrete or hard stone?
Carpeted, no question. Although
I'm just trying to understand the rationale behind it a little bit.
And really the case law on this issue across the country is kind of all over the place. I mean, you mentioned hitting your head on a desk on the way down. There's some case law. I think in Florida, I had the case before me, and I'm sorry, I don't have the site right now. But the worker did hit his head on a desk, and the court there said, "Oh well, you could hit your head on a desk anywhere. This is a normal piece of furniture, and it wasn't compensable." I don't think that would be the law in Arizona. But I think the better question. I think ultimately whether the employment conditions increase the risk of injury is a matter of fact up to the discretion of the ALJ. The ALJ is entitled to take evidence on the issue as to whether the existence of a counter or a desk or any other implement increased the risk of injury or not. And absent abuse of discretion, that finding will be affirmed. And
So just change this hypothetically. Okay, let's get rid of the soda fountain. It's
Yeah.
just straight wall, flat, straight wall, painted drywall. Hits the wall. Hits the wall, then goes down to the ground and hits his head. Does that makes it easier? Wouldn't you say that's an easier denial of coverage there?
I would think so in that case.
But
Because,
here we have the caveat of this opening, right? I haven't seen this door. I haven't seen the video, so I don't know exactly how this is set up. But so one place called it. Is it the soda fountain, or was it like? It sounded like it was another. Might have been a different kind of station for some unique specialty drink or something.
I think it was a normal drink counter. I'm not sure what exact type of drinks were being served there.
Okay, some kind of counter, but like cut into the wall, if you will, right? Like,
Yes.
Okay, so I'm picturing that. So naturally, your head or whatever would go. If you're falling into that, you're going to go towards the whatever the apparatus is behind in the wall.
Correct.
Okay.
Um,
Let me jump right in there. Do you object? Before I forget, do you object to us obtaining the video here?
no, Your Honors, no objection.
Okay.
And,
Let me ask you,
Yes.
there are cases from other states also that would extend the coverage, in this case, and make it compensable to have fallen into anything in the office, including the wall. I mean, that why wouldn't those cases extend in Arizona? Why does Valerio keep us away from that?
Well, this comes to the analysis of the origin of the risk. And generally with workers' compensation, you want to ensure that you're compensating people for injuries that in some way arise out of their employment. And so in this case, where the origin of the risk is purely personal, in order for there to be some logical relationship to compensation, you want to see that the employment really did contribute something. In this case, the standard is substantially, more than slightly to the risk. And it can't just be they touched something there, but something that did, in the case of a personal risk, something that increased their risk of injury above what they would have faced anywhere else.
So why in this case I just don't know that the wall is any easier than the counter If it's something that really is just there and the person leans into it and then falls after leaning into it, that's not that doesn't seem that it's particular to this workplace.
I think you're right. I think that the wall is maybe somewhat easier just because there are walls everywhere and there aren't drink counters everywhere.
But it's a counter.
Yes.
There's nothing special about this beyond it's a counter.
I agree, and I don't want to start arguing against my own
I
position here.
understand. Because when we call it a drink counter, we make it sound like it may be something else, but it's just a standard counter. Looks like it may, whatever type of top it is,
Right.
and something underneath.
And I think that's right. So I think, again, it's a factual question as to whether the existence of that counter did something to increase the hazard of this fall. Would it be different if it was a bookcase? Would it be different if it was a chair?
So other states have said, though, when it's just a counter and you didn't hit your head on the counter or anything, but if you fell into the counter and it was in the workplace, they've extended coverage there.
That's true.
So what's different about Arizona that we don't? That's what I'm trying to get to. Why don't we?
In the states that would extend coverage in those situations, I believe they've relaxed the requirement to show. They've relaxed the requirement to show some contribution of the workplace that exceeds normal hazards. That said,
so their standard is they articulate a slightly different standard, or are they using the same standard we do?
well, I'll confess I'm not intimately
Okay.
familiar with that case law. But my understanding is that in those situations, and there are some states that will find it compensable, even an idiopathic fall to a level floor will be compensable.
Sure.
And those states have essentially gotten rid of the requirement that there be an increased risk in the case of idiopathic falls. That's not the law in Arizona, and it shouldn't be the law in Arizona, because I believe we want to maintain some kind of real connection to workplace contribution to injury and not simply make workers' compensation a general insurer for any injuries that might occur while somebody is at work. So I think that's where you would distinguish it. Other states have maybe moved further in the direction of making compensation a more general insurer.
And is it fair to say, and I'll just, when we say, would you rather, and I appreciate the question, would you rather fall on a carpeted floor or tile floor or concrete? I think most people would say, please give me the carpet. But does that choice of carpet versus concrete increase the risk? That's, I guess, what the question becomes. Because it seems to me that maybe we should all have gym mats down all over the place to decrease the risk even more. Because even a carpeted floor could result in an injury that might have been avoided with a different type of flooring. So is the type of flooring an increased risk?
Under Valerio, it is not. And under the majority approach, I believe that's followed by most states, a level floor, even a hard floor, is not an increased risk beyond what people are generally exposed to in their daily lives that would warrant finding compensability. Normally, the increased risk cases fall into two categories, right? It's fall into a dangerous object or a fall from heights.
And so that's why, coming back to the wall and the counter, it's no different. Places have counters. Places have, rare business that doesn't have a wall somewhere. Even the open office spaces have a wall at the outside. So isn't that just part of it's part of existing?
I think that's correct. I think there's always going to be some factual matter that the judge is going to have to decide whether this wall is somehow a unique feature of this work environment. I mean, you could imagine that there's a place with oddly placed, unevenly sized walls that you
Pony
find.
wall.
I don't know. What?
Pony wall.
Sure.
Could be something that would be unique and different.
I think that's correct. But in whatever the case is, the presiding judge is first going to have to make that factual determination whether this is,
So,
unique.
for instance, if he was out, if this Mr. Gomez was outside on the, I don't know if there's a ramp, some sort of ramp, just assume there was for disabled purposes, there's a sloped ramp and the fall occurs there. Are you saying, I'm trying to understand your argument, you're saying that clearly that's just going to be a call for the ALJ to make on whether that would have increased the risk, or also to throw one more high point there, if it was out by the gas pumps and it was cleaning around the gas pumps and yet not tripped, but just had the incident, same fainting incident, and fell into the pump. Are all those, you're saying, I'm trying to understand, you're saying those are just purely going to be factual determinations by the ALJ in each instance?
I think that's right. Even if you fall into the gas pump, you're going to have to ask, well, did the pump, cut your face or cause a facial fracture, or did you just slump into it and then hit your head on the ground? In one case, it might be an increased risk, and the other it probably isn't.
Maybe grab for the hose,
Maybe
because that's something unusual about a gas pump.
I think those are all factual matters that the judge would have to take into consideration in determining whether it did increase the risk. A fall on a sloped walkway might be a little bit different, assuming that nothing about the slope caused the fall. I realize that's not exactly level ground. So yeah, there's still going to be some factual determination the judge is going to have to do. We did something about the slope.
Does any of this seem like fuzzy, arbitrary to you?
No more than the requirement of evidence in any situation. If you want to find that somebody's injury was caused by his employment or by any other type of accident of life, you're going to have some evidence. You're going to have somebody make a determination as to the facts, whether it's a presiding judge in the workers' comp or a civil jury.
True, it just seems bizarre. What you're saying makes complete sense to me. It just seems odd that in Valerio, the Supreme Court would draw this bright line to me, like saying, well, if it's a hard floor, that's a bridge too far. I mean, we're not going to go there. So, and even though it's a 3-2 decision, I know I understand that.
Yeah. I do agree that it does seem odd to draw a hard legal line there. For instance, in the PMC case, there the Court of Appeals decided, I guess as a matter of law, that the fact that this guy fell off of a ladder from a truck bed increased his risk. And there was no fact-finding below. They just decided, oh, nope, it was a fall from heights, therefore increased risk. And I was thinking, that does seem strange. Presumably, you'd still want the judge to say, yeah, the doctor testified that falling an extra 4 feet made his injuries worse. And the court didn't take that approach, right? So we have, Valerio as a matter of law, fall onto a level floor is not compensable, but PMC as a matter of law, fall from a ladder on a truck bed is compensable.
That's because you're making a comparative judgment, and that requires a baseline, and the baseline is called background risk. And so the court is saying floors are part of background risk. Falling 4 feet off a truck bed is not. I mean, that's sort of clear, right?
I think that's true.
Doesn't strike me as arbitrary.
Well, I'm okay.
But it could be. What if you're on the first rung of the ladder? I mean, what if you're 8 inches up and you fall? We're not going to. I don't know that this court is going to say, as a matter of law, you're entitled to coverage there.
Yeah, I think that's where it does get hard. At a certain point, you can say that, falling from this ladder out of a truck bed, if the judge had decided that did not increase the risk, that might have been an abuse of discretion because at some level it's so obvious. What exactly that point is, I'm not sure. I know Larson, when he talks about falls from heights, gives an interesting history. One of the first cases was a sailor fell 45 feet, and that was compensable in an idiopathic fall. Then it went down to 40 feet, then down to 30 and 20, and the distances kept getting lower and lower. And finally, I think a New York case dealt with a fall from a 2-inch height, and that they said, no, that's not far enough. So it does get to be a little bit fuzzy, especially when you want to make this a matter of law. Maybe there does need to be some legal bright line, but maybe it really is just this matter of discretion on the part of the administrative judge to determine how high is too high, how dangerous is too dangerous in deciding these kinds of cases. In any case, that's not the question we have before us. In the case before us, I believe that the judge was reasonable in her determination that the drink counter did not cause or contribute to the applicant's injuries, and the award should be affirmed. Thank you.
Thank you.
I'll be brief. Just to touch on your question about, having a preference of falling on a hard floor versus a carpet here. I think the case is in the minority. The focus is more of a but-for test. They know that you fell at work and there's a hard surface there because the injury. No one can say what would have happened if you were not at work. You may have been at home. You may have passed out in your bed. You may have fallen onto your beanbag, or you may have been up on the roof of your house and fallen there. So I think that's how those cases come down. In cases like this, to me, this is a legal conclusion. It's an ultimate factual finding. So I think the court needs to
Tell
consider
me how
that.
it's different. How is different to say you could have fallen at home in other places? Well, he could have fallen at home into a counter.
It's
He
no.
could have fallen at home. He could have fallen at some
I
place else.
I get that, but in that situation, if you're looking at a but-for analysis, well, I should rephrase that. It's knowable. It's known that he fell at work. It's known that there was a hard floor there. It's known that that's what causes injury. You can't say what would have happened if he had fallen elsewhere. And it's a thin test. I'm not advocating it. I'm just saying I think that's how it boils down. So my last question is the
So,
video.
sorry, if you're done with that point, it sounds like then you're just getting away from the notion of background risk. It's not a comparative thing, like we're discussing with other counsel, where it's like, floors are part of background risks and falling 4 feet are not. You're disputing the concept of background risk because you're saying basically we can't know what the alternative case is in which you might have fallen. So you can't make a comparison. So you as an absolute look at the quick trip and then you're done. That's what you're saying.
Not in my case. I'm just saying I think that's a general approach of
Okay.
how that's viewed. And in my case, I'm saying that the makeup of the store contributed to how he fell. And he didn't fall onto a basic counter. This is a rack with drink cups and chips and that kind of stuff. And when you get the video, you'll see that. So with respect to the video, should I ask the commission to supplement the record on review?
From my perspective, unless either of my colleagues object, I'm going to say yes. How much time do you need to make that happen? How many days?
I can contact them today. I can contact the chief over there and tell them, hey, you missed something.
We'll allow you just for 5 days.
Yeah.
5 days to get that filed, to get the record, get the video transferred.
So will you submit an order, or? I mean, I can tell Guy Testini, hey, you need to get this up here, and I'm sure he'll get it
Yes,
done.
Sounds like an agreed motion to supplement the record,
I
right?
think we're in agreement. I think go ahead and do it.
Okay, I will do that then. Thank you.
And take care of it. Thank
This
you.
video will be posted if he has any questions at the end of our argument.
Okay, very good.
Okay.
Thank you.
All right. Okay, thank you both for your arguments this morning. We'll stand in recess and set up for the next argument. Thank you.